Think tank joins us now on the line. Ms. Pheko, thank you very much for your time. We were speaking to Prof. Mkhwebane a bit earlier on, and I just really wanted to establish from you, the both of you, whether the president politically would be able to act following a second batch of damning findings now against the Public Enterprises Minister Pravin Gordhan.
Yeah, so it really depends on how far we want to interpret the law, and I think that what he had said originally was that he was awaiting the legal findings of this, which illustrates that although the Public Protector's office is persuasive, it isn't actually the final word. So what the Public Protector's Office has the right to do, certainly, is to put in place a set of recommend remedial actions and to investigate improper prejudicial conduct, investigate maladministration, and to advise on appropriate remedies to the above. But the Office of the Public Protector cannot by any means prescribe what those remedies should and should not be. And this is where the law becomes a bit fuzzy, because some people have suggested that even though the Office of the Public Protector, just like all the other Chapter 9 institutions, is not per se a prescriptive body, and that it's very important that all of the Chapter 9 institutions are independent and are subject to the law and to the Constitution, this does not prevent them from actually being able to be a bit creative, because it's a form of jurisprudence, isn't it? It's a form of trying to create ways and mechanisms of stretching its parameters. But, certainly on the face of it, or prima facie, as the lawyers would say, she hasn't, the Office of the Public Protector can advise but cannot prescribe. So, in fact, the President, if we follow that principle to the letter, is not per se obliged to take on her recommendation, although, of course, if he is upholding the law and the Constitution, it does present a quandary if he appears to be obstructive in any way.
So the president not prescribed to take on her recommendations, then I guess a conversation, that needs to be had is about the role of the Public Protector's Office, in particular in this instance, directing the president on what to do, and what would be overreach in this particular instance.
Yeah, exactly. So, typically, what we understand the role of the Public Protector to be is exactly that: to protect the rights of citizens, certainly to protect the rights of the Constitution, to uphold a constitutional. The Constitution in this country, and also to suggest that, of course, under the PFMA, to investigate improper and prejudicial conduct in state affairs and public administration, to investigate it, and to report on those findings. So I think in this regard, it means that the role of the executive and the role of the Public Protector may become conflated, because if we get into a situation where it is seen that it is perceived that the Public Protector can actually direct and prescribe the office of the President, then it begs the question, then who is the most powerful person in this country, and which office has the precedence? And of course, it cannot be that the Office of the Public Protector has precedence, but it also presents, as I say, a bit of a quandary, because if we take this to its furthest conclusion, and the Public Protector is insisting that of course, no one is above the law, which is an important principle, then the President must then reflect on what this means constitutionally.
What could possibly also be damning for the Public Enterprises Minister? We're hearing from that report, of course, is that the Public Protector essentially saying that there's no way that Pravin Gordhan did not know about the operation of this unit at SARS, and she says also evidence, of equipment that was purchased in order for this operation to run. Talk to me a bit about that, and perhaps also include, Ms. Pheko, instances where, according to the Public Protector, there was illegal tapping of communications of some sort in order to source some information from powerful individuals.
So, I think it means there are a few things that we can think about in this regard. The one is really the extent to which there has been a massive confluence in the governance in this regard. So the ways in which governance takes place, privacy issues, and the extent to which there's a lack of transparency, and where autonomy begins and something perhaps more nefarious begin, when autonomy ends and something more nefarious then comes into play. And I think that the other thing is the extent to which private entities are part of governing our country. So we have, private security companies, private tapping companies, and what this means in terms of state security and also accountability. So why, if all of this is true, which it may in fact be very, very true, it means then that there's a lack of mutual accountability at cabinet level, at NEC level, and that a particular minister and particular ministers may have the capacity in some way to behave in a way that is beyond collective accountability and collective responsibility.
Ms. Lebohang Pheko, Senior Research Fellow at the Trade Collective and Think Tank, thank you very much for joining us there on the line, unpacking, of course, the report that was released by the Public Protector. You have a great weekend. Thanks for joining us.